Hello and welcome to the Moot Probe, the new podcast from the Department of Digitalization and Innovation in Law, today for the first time in English. Unfortunately, my co-host Johanna Göschelberger couldn't join us today. With this podcast, we want to give an insight into the world of moot courts. Moot courts are simulated negotiations in different legal disciplines. Today, we will talk about the Frankfurt Investment Arbitration Moot Court. Before we will start, I want to give a short introduction of our interview partners. Julia Hildebrandt graduated from the University of Vienna a year ago and works as an associate at Knötzl, Haugeneder Netal Rechtsanwälte, a boutique law firm specialized in international dispute resolution. Previously, she worked for more than 2 years in international law department as a student assistant for Professor Griebaum. And in 2018, she participated herself in the Investment Arbitration Moot Court as a team member. And for the past 3 years, she was coaching the Moot Court. Hello, Julia.
Hi.
Alexander Kallis studied law at the University of Nottingham and is doing a LLM at the London School of Economics and Political Science. He's specializing in international business law. He participated in the investment moot court in 2019 as an Erasmus student for the team of the University of Vienna. The team achieved the second place at that time. Sophie Aulitsky just graduated from Uni Wien and is doing her judicial year. She participated in the investment arbitration moot court last year. The team reached the second place in the pre-moot in Moscow. The moot court was unfortunately cancelled due to the corona crisis. Sophie Tesarik studies at the University of Vienna and also participated in the International Investment Arbitration Moot Court last year. I would suggest that we get right into it. Why should someone participate in a moot court? It's a lot of work, so why did you join the moot court?
Sure. Well, thank you very much for having me. I think there are two reasons why doing this particular moot or mooting in general is a very good idea for a student. The first reason is that it really develops practical skills which are otherwise very difficult to obtain at university. And by that, I mean particularly written and oral advocacy. It would build your confidence quite a bit and your ability to work in a team, which are obviously characteristics of a very good lawyer. And that brings me to my second point, that completing or competing in mooting is excellent for career progression as well. It is, until this moment, one of my most impressive thing on my CV. And it really demonstrates to potential employers that you have the capacity to work very hard and succeed. So I think for those two reasons, which you can't really get at university stage in many different ways, is why you should totally consider joining a moot.
Yes, I think those aspects are really speak for a moot court, and I hope it motivates the listeners to participate in one. And from which aspect of the moot courts did you benefit the most?
Oh, for me, it was actually just the fact of pushing myself out of my comfort zone. You see, before I joined the moot, I was actually quite convinced that I'm quite afraid of public speaking, but then I did it and it went pretty well. And I'm currently pursuing a career which is all about oral advocacy. So I think that was a very important element to my whole academic experience and progression. And many of the successes I currently have are linked in some way back to having completed the Frankfurt moot.
Yes, but those public speaking skills you can you have in a lot of moot courts. Why should you participate in the investment arbitration moot courts? There are many options.
I think because the investment arbitration moot court focus very intensely on the verbal presentation, not so much on the written submissions. And so personally, to present the case was also the skill I learned the most intense from that moot court. And you also really have to honor your skills in the sense of listening to what you say, what the arbitrators say, and what your opponent says, to have a good rebuttal or to answer questions very intensely. And I'm not sure, I've only participated in that moot court, but while talking to other mooties, I'm not sure if this is so much the focus in every moot court as is in this one.
Yes, and Julia, what is your opinion on that? What is different about this moot court from others?
Well, I fully agree with Sophie on this point, and would also just add that for the Frankfurt Investment Arbitration Moot Court, what is special is that we do not have a big written phase, like, for example, for the Jessup Moot Court. So all you have is so-called skeleton arguments, which are bullet points of your arguments. And that gives us the opportunity to start from the beginning with the presentation and the development of your English skills and presentation skills, instead of focusing first just on writing. And that's, I think, very good if that is your goal in participating in the moot court, to improve your English skills and your presentation skills.
And a lot of students are of the opinion that moot courts are only for the best students with maybe the best 5%. How do you apply, and what is required from your student? Do you have to be a straight A student?
No. So we never request your transcripts. We don't want to know your grades. All we want is a CV and a letter of motivation. And then we're going to invite the kind of first narrowed down group to an interview round. And after that interview round, we decide who is going to be part of the team. What is also maybe relevant for people that want to apply is that we choose 4 people, and all 4 people are going to plead in the moot court. So there is no research team or someone who will not have the full moot court experience. Everybody is going to have the full experience here.
And we heard a lot of positive effects of a moot court, but do you also get ECTS credits for it, or is it just for fun, let's say?
Yeah, that's a very relevant question for the students. So you get 4 ECTS for the winter semester and 2 ECTS for the summer semester, because the moot court happens in March. So the whole thing is done after the first month of the summer semester. But you also have the possibility to gain extra ECT if you submit us a paper on your topic, and you have the possibility to have 1 or 2 seminar papers in the course of this moot court.
Yes. And once a student successfully applied, how is the supervision? Do you get in contact with law firms, and how does the coaching work?
So the coaching works in the way that first we meet the students twice a week. And as I said, we don't have a written phase, so we start already with the presentation. And of course, with teaching investment law and public international law, because mostly when the students start in this moot court, they do not have the in-depth knowledge that is needed for the moot court itself. So this is the first 2 months, approximately 2 to 3 months until New Year's. And then we start with 3 sessions a week. So it is a lot of work. In these 2 to 3 sessions, we are mainly pleading for hours. And also, of course, we are there for the students in between. We're very flexible in that manner. If they need help with the argumentation, if they need if they have questions or want extra knowledge, they can always call us. So I think it's a very personal experience.
Yes, it's definitely very personal. You almost feel one-on-one with your 2 coaches. And pleading is essentially just a simulation of the moot itself. So I remember from the first sessions on, when we didn't just come to have a conversation with our coaches, but we had to come with our arguments essentially prepared, no matter how bad or how unresearched. They had been at the beginning point, and we just had to really focus on our verbal skills from the get-go. And the question that you also asked before concerning employment contacts. So we had arbitrators come in that, so we had a tribunal of 3 people, not just our 2 coaches. But it was usually people from academia, so university professors, previous mooties. So for our year, we had little contact to firms, but it was very interesting to be connected to academia and get connections at the university itself, which is also a very interesting career prospect for somebody who wants to go more in depth into research or become a prédoc and pursue a PhD or further degree.
Yes, and the massive workload was mentioned. Could you do other courses next to it, or was it so much work that you just should do a moot court in a semester, for example? So
the Frankfurt investment arbitration moot is from its timing, it's rather practical because it falls right into the semester break, so the February vacation. So the moot is usually beginning of March, and the pre-moot that you get to take part in is in February, which is usually a time where students don't have university. So the really intense phase lines up quite well with your regular university schedule. And for my case, I did my normal exams in November. I had the luck that I only had 1 more exam left after that. So I chose to take the time for the moot and focus on that more in-depthly. But I definitely agree with anyone who says that you can pursue something else in the meantime. But maybe in January, you want to focus more on extracurriculars, so Wahlfächer, and take more time for the moot, because essentially you only get 1 shot to perform at the moot itself, and 1 exam phase, more or less. Yeah, I mean, yeah, it's a once in a lifetime opportunity, essentially.
And how big is this competition? How big is the Frankfurt Investment Arbitration Moot Courts? How many participants are there? Is it a worldwide competition?
It's a worldwide competition with 45 teams in the main round in Frankfurt. You have country pre-selective rounds in, for example, India and France. So in total, there are about 60 teams that compete in different rounds. And it's very interesting because the global aspect is not just in the teams and the universities that you meet, but also in the arbitrators. So the arbitrators that are going to evaluate your performance in the moot court are from all over the world, from different law firms, universities, but it's a highly practical group of people, of arbitrators and counsels. So this is, I think, the most charming aspect of the moot.
I would also just like to add that perhaps the career prospects take full bloom more in Frankfurt itself, where you get to meet arbitrators from all over the world, and those who see you perform well. I mean, you can immediately communicate with them and connect with them. Unfortunately, due to COVID, we weren't able to do that, and maybe with a digital form, it's also more difficult. But that was really the beauty of it, that you can network there.
That's maybe a good point. That's interesting for students. How does it work in times of COVID? But please, Alexander, go ahead before someone answers the next question.
Sure. Just to add, because I've had the moot before COVID, so there's actually a lot of events around the moot as well. So we've had an event at Debevoise Plimpton in Moscow, which involved receptions and a number of different talks of some quite famous practitioners. And in Frankfurt itself, there was an event with, I believe, Freshfields as well. So I think there's plenty of opportunities to network, to really make some connections, which is, you know, another great advantage of doing mooting.
And how do you make the connections now in times of COVID, Julia?
So now it's, of course, very, very different. We just had the pre-moot last week. The Milan pre-moot in this case. Normally we participated in either Paris or Moscow, so you travel there and you meet at least a number of teams already in the pre-moots, which are kind of a practice round for you. So they do not count for the moot court itself, they are just for the students, for their first experience in mooting. But this year, all was virtual, which has some implications. On the one hand, it is harder than an in-person pleading. Virtual pleadings, even in practice, are always more tiring. So it's even more work for the students. You have technical issues. Luckily, in our case, this didn't happen, but it may happen that you have technical issues on the side of the arbitrators or on your side. That is also something that makes it a bit more complicated. On the other hand, what we saw in the pre-moot was that the organizers really tried to get the social element into the virtual moot. So there was a whole conference that was happening virtually. There was a lot of possibility to exchange in breakout rooms, to talk with other teams. There was an exchange of email information for if you had to exchange so-called housekeeping rules with the other teams. That means your pleading has a time allocation, an order of claims that you're pleading. All these things normally will be addressed with the other team in person before you're pleading. This is not possible, so we have all the email information that we can exchange with the other teams. And we even had a friendly pleading round with another team virtually with a law firm this year. So there are, on the one hand, more opportunities because everything is virtual. People don't have to travel. Universities that don't have the money can participate in the moot court. And on the other hand, there are elements that are harder for the students, especially connected to the virtual pleading.
Yes, and as you mentioned money, how is it in normal years to say, are the travel expenses paid by the university, or do the students have to pay them by themselves?
Well, in our case, it is all reimbursed by the university, however, after the moot court. But we are giving our students financial support in this regard. So it's not like anybody is left behind just because of money, and you will get everything back from the university.
And maybe not everyone is familiar with international investment law. What are the cases about in the moot court, and how does such a case look like?
Yeah, so the feature of this moot is that it is, I believe, usually or always based on historic facts. So in 2019, our entire case revolved around a colonialist struggle between France and Britain in what is currently Canada. And our claimant was an ethnic minority member who was caught sort of between this power struggle. And the way it works, so obviously the facts are very interesting as a result. You are given all the documents in advance in a bundle. For us, it was less than 100 documents of the facts themselves. And in addition, you would get a set of basic legal documents, which would be your main authorities for your pleadings.
And what is the fascination of international law about, your personal fascination? Why did you choose this moot court?
So personally, I had was of the opinion of, had a pretty negative opinion about investment arbitration, and the more I learned, the more I saw that the nuances to that field. And personally, what I find really interesting is the structure, that you have this mainly bilateral treaties that are pretty similar but not the same, and then you argue mainly with the cases, and to really distinguish under which circumstances did the tribunal decide what, under which circumstances which legal argumentations were used. So it's a very interesting style of argumentation for me. I really enjoyed that.
And lawyers want to categorize disciplines and general stuff. Where does it belong to? Which kind of legal field is international investment law?
Well, international investment law is basically a subfield of public international law, but at the same time, it's special. Because if you think about public international law, you normally think about states or international organizations. And in investment arbitration, you have an individual or a company and a state. So it's a special area in public international law, but it's still governed by the same principles and rules. And maybe just to add very shortly to what Sophie said, what is also very interesting about investment law is exactly the arbitration part. And that it is an arbitral tribunal that decides on the disputes here. And arbitration always offers you the possibility of having a mixture of common law and civil law. So that is also something that is really interesting, I think, for students from the University of Vienna that are mostly taught civil law and civil procedure law, that in common law you have these specifics of witness examination, cross-examination, and that is what I personally think makes arbitration so attractive.
Yes, and as you mentioned, those cases are not discussed in front of in a courtroom. What is the forum in the moot court? Where is it heard?
Yes, so it's an arbitral tribunal, which means there are mostly 3 people. One arbitrator is chosen by each side, and then there is a third arbitrator, the so-called presiding arbitrator, that is either chosen by the 2 other arbitrators or by a so-called appointing authority. The appointing authority is mostly an institution like the Court of the ICC or the PCA or ICSID. And what is very interesting for arbitral tribunals is they are independent in the sense that, of course, courts are also independent, but an arbitral tribunal does exist free from any national system.
And what are the career prospects for an expert in international investment law? And are there cooperations with law firms, or is there a possibility for students who participate to maybe get a job opportunity?
Yes, I think totally. For instance, I work with investment arbitration right now in the academic aspects of investment law. So obviously, I've really followed up on what I've learned. It was also my subject for a dissertation. So I think there's a lot you can bring from this subject, which is investment law, which has so much in it, public international law, and arbitration, and you can really venture out from there. What is also a highlight is that we do have a sponsor, at least in our year, for the competition. We cooperated with a law firm, Knützel, in Vienna, and I believe 2 of our members have secured employment after that. So I think it's a great opportunity to make real networks and then gain something tangible from it.
Maybe if I add there just shortly, I am working currently for Knützel, and I really think that the moot court was the reason, because I was asked to work there for an investment arbitration case to support the team. And so I was able to actually gain practical experience in investment arbitration, which is not so ordinary in Austria. So this is what I think, why I think that the moot court can really help you in getting better employment chances, especially in the field of arbitration. And we will always try to cooperate with more law firms and different law firms. And arbitration is a big deal in Austria. So if you jump on the train, the moot court is a good possibility.
Yes, and maybe another question about the topic. It's a little bit critical. Investment law can often lead to governments, often of smaller country, non-developed countries, that the legislative freedom is maybe restricted. I'm thinking, for example, of Philip Morris versus Uruguay, where Uruguay wanted to implement a new non-smoking initiative, and Philip Morris tried to stop it. Is there too much power for big corporations, and, for example, represented by international top lawyers?
Sure. Well, I think it's a very big issue, which will be particularly aggravated following the COVID-19 pandemic, which will result in a number of regulatory measures, or has resulted in a number of regulatory measures on behalf of states, and also Brexit. From my UK perspective, I think the really important issue here is that the ability to challenge regulatory freedom might grant the foreign investors more rights than it would grant to domestic investors, which is the big objection that, for instance, Australia made quite recently. And even more critically, it might prevent states from passing quite essential legislation, for instance, environmental legislation, as we have seen in the Vattenfall cases, for instance. But so the future is obviously very interesting. It's very interesting from the state perspective as well, because states inevitably feel like that's not what they signed up for. Investment law has evolved into something that quite restricts them, even though when they signed all the investment agreements, they rather envisaged something different, envisaged arbitration to stem from contracts rather than treaties, so to be much narrower in their scope. So I think, just to look a bit ahead, we will likely see investment agreements being more specific about the requirements therein, for instance, definition of an investment. And we will likely see tribunals affording a bit more of regulatory freedom to states, which is a trend which we can see in a number of recent cases, for instance, Hydro Energy 1 and Spain, which will suggest that, yes, we should afford some margin of appreciation in the end. But this is a very hot topic, I agree. So if anyone has any thoughts, please feel free.
I would jump in here. You mentioned the Philip Morris versus Uruguay case, and I actually think that's very funny because this case was actually decided in favor of the host state. So it was a rejection here, and that is basically something that goes to the fact that when there is a claim raised by an investor, a multinational company, a big conglomerate, then there is a lot of press coverage. But when there is a decision that goes against that claim, that actually dismisses the claim, then there is very little coverage, which is probably why there is so much bad news about investment arbitration. And on the other hand, what is also interesting, in my opinion, is that more than half of all cases that are filed are already rejected in the very beginning, so in the so-called jurisdictional phase. And then when you only have less than half of the cases left, the biggest part of that is rejected on the merits. So in the end, you have a very small part of all claims that are filed that is actually successful. And then taking into consideration that some of these cases are decided without any damages awarded to the company, so basically no real profit for the company that filed the claim, I think that the public opinion about investment arbitration is very bad compared to what is actually happening in investment arbitration, specifically when it comes to the issue of states being subjected to maybe unfair claims.
Yes, and for instance, in Austria, there's a lot of trust maybe in the statutory courts. How is a fair trial guaranteed in front of such a tribunal?
That's a very interesting question. Well, first of all, arbitral tribunals are comprised of counsels and lawyers and even ICJ judges and arbitrators. So these people are, from their nature, lawyers and legal scholars. So they have a certain understanding of fair trial, and they will most definitely try to conduct a fair trial. So there is a lot of trust from the side of the parties in the arbitral tribunal. And also arbitration was actually created because of the idea that a national court that would decide on the case of a foreign investor against that state may be, even without knowing it and wanting it, biased in favor of that state. So arbitral tribunals are there to actually guard due process.
Okay, I think that's a good outlook. Thank you very much for participating. And maybe can you state again where you can find the moot court, on which website, or how do you apply? Where can students find it?
You can find it in the Lehrveranstaltungsverzeichnis of the University of Vienna and on the website of the Department for International Law and International Relations. And you can, of course, always send an email if you have any questions, either to me or to the department secretaries. And if you want to apply, we will start the application phase again before the winter semester next year.
Okay, thank you all for joining, and I hope everyone enjoyed this session, and I hope a lot of students will apply now. I think it's a really